Hi, good afternoon on the East Coast. Good morning out west. This is Aaron Lacey, joined today with Jeff Fink, our litigation partner, and you are listening to Decoding the Final Borrower Defense Rule. This is a webinar series that has been brought to you by our higher education team. This is the fourth in our four-part series, so if you're one of the folks who's tuned in for all four, thank you very much. We sincerely appreciate it. Also, please remember that if you're listening to this sometime after the original air date, it is possible that law and guidance have changed, and particularly because this is an area where we expect, like many areas of federal law right now, for there to be some significant change over the next 60 to 90 days when the new administration takes over. You definitely want to be mindful of this point. I mentioned earlier this is the fourth of our four-parter. Today's topic is the elimination of the pre-dispute arbitration clauses and class action as well, and the new repayment rates for proprietary schools. We're going to spend most of the time on the first part of this because of the way that the proprietary rate has played out. It will be a minority of the presentation, but we'll definitely get to both. Don't worry. I mentioned I'm Aaron Lacey. I'm in our higher education practice here at Thompson-Coburn, and for those of you who may be tuning in for the first time, we are a law firm. So I'm an attorney. My partner, Jeff Fink, is an attorney. We have getting close to about 400 attorneys in the firm, so we're pretty big, and we're based in St. Louis and have locations in other places like Los Angeles and Washington, D.C., Chicago. In the higher ed practice, which is the area, so I focus on, we do three main things, or I like to say the things we do fall into three main buckets. We provide regulatory counsel on federal, state, and accrediting agency laws and standards that affect higher ed. So this would fall into that bucket, right, talking about the borrower defense rules. We assist with post-secondary transactions, so we expect a lot of the people tuning in today are probably with for-profit institutions, as the arbitration provisions and the repayment rate will likely have the greatest impact on the proprietary sector. Well, one of the things that happens in all sectors, but with increasing frequency in the proprietary sector, is the acquisition and sale of schools. So one of the things we do is help people through that process. And we do all kinds of contracts and policy design, all that kind of stuff. And then finally, we represent institutions in student and employee litigation, government investigations, administrative proceedings, audits, and reviews. So the part of that I often focus on is the administrative proceedings or investigations. So if you had a program review with the Department of Ed or something like that, an accrediting agency action, I might get involved. And then our litigators, they do student and employee litigation, which brings me to Mr. Fink. So Jeff is partner in our litigation practice, defends lawsuits and arbitrations brought by state attorneys general, former students, has done that in multiple states along with other members of this practice, and dealt with a range of claims including fraud and violation of state consumer protection, often the basis of many of the claims brought by students, and False Claims Act representations and employment opportunities, et cetera. Also, our litigators challenge government suspensions and financial aid programs to include in the veterans benefit programs, and defend employee-related litigation. And I just want to take a quick second. The folks who, and I'm going to say this because Jeff is a modest guy, which is an unusual trait among litigators, you might say, but would not say these things. I will. Most of the people who tune in know me, or I've met you at conferences and have some familiarity with our regulatory practice. But I just want to highlight that our student and employee litigation practice is actually extremely active. I understand over the last 3 years we've had over 60 student suits or arbitrations. That's in states pretty much across the country, from Massachusetts to Missouri to New Mexico. They handle civil investigative demands. They've dealt with attorney general investigations in multiple states. So these guys really know what they're doing, and they do a lot of it, and specifically in the school sector. If you have questions about litigation or things that are like litigation, concerns at your institution, and you're looking for someone to represent you in those matters, we would love to talk to you about that, obviously. And so if you know me and you don't know Jeff, give me a call, and I'm happy to introduce you to Jeff and the other members of the team, or to provide you more information, again, about the litigation practice. So today's outline, we're going to start, as always, with politics and prognostications. We'll look at the new rule from 40,000 feet. Then we're going to dive into the class action and arbitration provisions. And finally, we'll talk about the new, and I have it in parens because, as I'll discuss, it's not so new after all, repayment rate. Starting with politics and prognostications. So the big question that we've tried to think about a little bit at the beginning of all these presentations is, will this rule ever go into effect? You're seeing a lot of literature and folks speculating about a Congressional Review Act. So this was a piece of legislation that came along in 1996, and it permits Congress and the President to effectively kill a regulation. They call it a resolution of disapproval if that regulation has been reported to Congress within 60 legislative days of the point at which they take the action. So really what this means is Congress and the President have the ability, even if a rule has been promulgated by an agency, to kill it. One of the important notes is the 60 legislative days, but it's important to understand too that legislative days are very different from calendar days. The Congressional Review Service has taken a look at this. That's the folks in D.C. and the government who will do reports and analysis for Congress. And they have speculated that any regulation that was reported to Congress after May 30 of 2016 would potentially be subject to a Congressional Review Act action. So that gives you a sense of how few legislative days there really are in the calendar. So there's a lot of regulation that's come along in that period, and we think it is almost certainly the case that the Bar Defense Rule would potentially be a subject of a Congressional Review Act type piece of legislation. So Congress, both sides of Congress would have to pass and the President would have to sign it. But another important point is under the Congressional Review Act, it's essentially filibuster proof. You just need a majority, right, rather than what typically would be 60 votes. So we think there's a likelihood that that will happen. Other opportunities, too, you could have a removal through rulemaking. So the Department could actually start a new rulemaking process for the purpose of reevaluating and stripping out or totally killing this set of rules. The next administration could also say, you know what, we're just going to suspend enforcement. And then the final piece potentially is you could still have one who or some entity that would lodge a legal challenge against the rule, and then the department might ostensibly choose not to defend all or some portions of the rule in that challenge, which would basically mean that it would go away, assuming that the judge acted in that manner. The other point I want to make that I haven't made in the prior presentations, but I think is really important here is, you know, I have some concern. I think the CRA is an important option here when you're talking about these arbitration provisions, right? Because here is my concern. If you don't see a CRA, right, but let's say the next administration just says, well, we're just not going to enforce this rule. That still means that as of July 1, as we're going to discuss later, as of July 1, 2017 of next year, there would be a federal law on the books that basically says that you as an institution can enforce a class action waiver or a pre-dispute arbitration clause. And if there is a plaintiff's attorney out there who takes that to court, I'm not sure how that's perceived. The fact that the Department of Education isn't choosing to enforce the rule or is engaged in a negotiated rulemaking process to potentially strip out or change the rule still would have no impact. You would still have the federal rule banning these provisions on the books, and I'm sure that's what a plaintiff's attorney would point to. So at least with regard to the arbitration provisions we're going to discuss today, I think that the CRA would be really important, because that would be an act of Congress that would literally strip the rule away before it ever became effective. You know, with a lot of the other pieces of the bar defense regulation that we've talked about previously, if the Department of Ed isn't enforcing it, there's basically no exposure to schools, or there would be very little exposure. But here, I think with the arbitration provisions, a CRA is an important, the important option, or at least the one that would be most effective in limiting an institution's exposure. There's a couple of three other things to remember. I mean, you know, even if Congress doesn't act, you've still got a borrower defense rule on the books, and whether or not the aspects of this particular borrower defense package are acted upon by Congress or by the department will largely depend on whether or not this is a priority for them. And I've said this every session, you know, if you have concerns about this rule or this package, if you are talking with your associations at the state or national level, I would suggest that you encourage them to make sure that these concerns are percolating up and through and they're being recognized at the congressional level, because there are lots and lots of folks out there and lots of industries with concerns right now, and they are all trying to get to the next administration and the Congress to voice these concerns. So it's important that you don't take for granted that the folks at the congressional level will just know about your concerns and or make them their own, right? So let's talk about the new rule from 40,000 feet. We've talked about, you've seen this slide before. The bar defense rule has lots of different pieces. The actual bar defense mechanism being the headliner, and then financial responsibility triggers probably being the second most significant in my mind. but very closely behind for proprietary schools in particular that have enrollment agreements. You've got the arbitration provisions that we're going to talk about today, and then the repayment rate piece, that is the only piece of all of this that is truly specific and limited to proprietary schools. This is just the implementation timeline. If Congress and or the next administration weren't to act, you would expect these rules to become effective, or they would become effective July 1 of 2017. There are a couple of elements that the department has selected to pursue early implementation on their part, and we talked about that on Tuesday with the closed school discharge provisions being one of those. But the stuff we're going to talk about today would become effective July 1 of 2017. So what I'm going to do is walk you through what the final rule says about class action and arbitration provisions, and then Jeff's going to sort of give you some analysis and thoughts about the authority of the department, and also some things that you all can be thinking about between now and then in terms of how you might be managing any arbitration clauses or class action waivers that you have. The first thing I'll say at the outset is, of all of the different pieces of this rule, this piece is the one that changed the least between the proposed regulations and the final regulations. Now, there were 2 or 3 changes, and I'm going to address those here. But if you were to go back to the webinar series we did on the proposed rule and compare the arbitration section that I'm about to go through with this section, you would see that they are very, very similar. In other words, the department didn't budge much when it came to its position on arbitration. So the HEA directs the department to enter into agreements with institutions to participate in the direct loan program. You guys are all aware of this. Everybody's got a PPA. That's in section 685, in section 685-300 of the regulations. It requires institutions wishing to participate in the direct loan program to enter into this written agreement. And I'm pointing this out because this is the entry point for the arbitration provisions. It's through the agreement that you sign with the department. The direct loan program agreement is part of each institution's PPA, as I just mentioned, and it includes actually a section, if you were to pull out your PPA in the scope of coverage, and this is the boilerplate. It says this agreement covers your eligibility to participate in the HEA programs, and then if you go down a little ways, you'll see the Federal Direct Student Loan Program is one of those that is detailed. So pursuant to the HEA, the department is directed to include in that agreement, in that participation agreement with you, the institution, among other things, such other provisions as the Secretary determines are necessary to protect the interests of the United States and to promote the purposes of this part, and that's the direct loan regulations and statutes. So the department has inserted this new arbitration, these new arbitration and class action requirements into the PPA pursuant to this authority, or at least they claim that they are able to do so pursuant to this authority. So, in other words, the new prohibitions on class action waivers and arbitration clauses are now going to be a condition of participation and would begin to appear in the PPA. The department, because it has to in order to claim that statutory authority on the prior slide, contends that these requirements are necessary to protect the interests of the U.S. So that's, again, the entry point from a regulatory perspective for the inclusion of these requirements. The new requirements would only relate to student claims or complaints that are or could be asserted as a bar or defense claim. This is a really important point, right? So insofar as we're discussing here today, limitations on class action waivers and limitations on pre-dispute arbitration agreements, we are only talking about those limitations insofar as they would apply to claims or complaints that are or could be asserted as a bar or defense claim. So if you've got a slip and fall, right, you could ostensibly have a pre-dispute arbitration agreement with a student that governs how you're going to manage slip and fall claims, right, because that would not be the basis of a bar or defense claim. Similarly, in the first presentation we did in this webinar series, we talked about the 1995 guidance from the department, and in that guidance they noted that claims of sexual assault or violence, those types of claims also would not be considered to be bar or defense claims because they don't relate to the educational services provided by the institution for which the loan was taken out. So again, there are certain types of matters that could arise and that could be subject to a class action waiver or pre-dispute arbitration agreement. But if it's a bar or defense claim, that's not the case. So for purposes of this presentation, if you see the little box at the bottom, we're just going to refer to these as qualifying claims, so we don't have to keep repeating the lengthy definition of a bar defense claim. But just remember, these claims, the waivers, the prohibitions on waivers and the restrictions on arbitration agreements are only with regard to that class of claims. All right, so what are sort of the suite of new restrictions? And I'm going to go through each of these in detail. First, there's guidance. Schools are prohibited from completing or compelling the exhaustion of internal remedies when it comes to these types of claims. They're prohibited from enforcing class action waivers, and there's mandatory language you have to include now in any future agreements, and that you'll have to either include or disclose with regard to past agreements. Similarly, there's a prohibition on pre-dispute arbitration agreements or clauses in your enrollment agreements or any other kind of agreement with a student, and there's, again, this mandatory language the department's going to require you to use. And finally, there are, and importantly, some notification requirements. You know, one thing that is sort of a theme throughout the bar defense regulations in all aspects is you have all these increased notification requirements, whether that's with regard to bar defense or financial responsibility triggers or closed school discharge. So if this rule or elements of this rule sticks, I mentioned this on Tuesday, it's really important that you get with your general counsel or compliance folks or whoever would be aware when these triggering events occur, because it is absolutely unlikely, in my view, that most financial aid personnel are going to know when all of these different things might happen, right? It's going to require coordination, and it's been my experience, frankly, particularly on the nonprofit side of the house and public side of the house, that the financial aid folks aren't always that closely coordinated with their general counsel's office. So one of the things we're encouraging you all to do, again, to the extent these rules stick, is to try to work a little bit on that. It used to be that there were not a lot of things that you had to report to the U.S. Department of Education. That has really and dramatically changed over the last 4 years, both with gainful employment and then again with the new bar defense framework. So let's walk through each of these in just a little more detail, and then I'll turn it over to Jeff. The exhaustion of internal remedies. So specifically, schools are prohibited from requiring students to first seek resolution of these qualifying claims, right, these bar defense claims, through an internal process. You know, some people do this, some people don't. I mean, in the enrollment agreements I design, I usually include a clause or something that makes pretty clear that you can reach out to an accreditor or an agency at any point in time. But I have seen enrollment agreements that say, look, you have to go through our internal process and exhaust it before reaching out to an outside party. And they're basically saying here that you're not permitted to do that. So students have to be allowed to go directly to an accreditor or an appropriate government agency. The class action prohibition, and again, this is a little bit of a simplification, but for the most part, schools are prohibited from relying on any type of class action waiver in a pre-dispute agreement. And so relying, there's a definition in the regulations, and the department sort of breaks it down into the different types of things you might do in the context of litigation to enforce or otherwise rely on a class action waiver. And they literally contemplate different points in the litigation process where someone might try to do that. Here, just generally understand that they're trying to get at everything, right? So they're trying to prevent institutions from relying on a class action waiver pretty much in any context, any type of litigation context. And that's for agreements with a student who received or benefited from a direct loan and with respect to any aspect of a class action that relates to a qualifying claim. So it has to be with a student who received a direct loan. Remember, the hook here is your participation agreement with the department that covers your participation in the direct loan program. So I think the department, I mean, they are essentially acknowledging that they don't have the ability to prevent you from entering into a pre-dispute arbitration agreement with a student who's not participating in the federal financial aid programs, right? So they do limit it to students who received or benefited from a direct loan, and again, it has to be with respect to a qualifying claim. Now, it does not have to be in an enrollment agreement or in a freestanding arbitration agreement. I also want to make that clear. You know, and to that extent, these rules do not specifically and only apply to the proprietary sector. It is conceivable to me that there are public and private nonprofit institutions that may have agreements of one type or another with a student. And you'll recall when we were talking about the bar defense rules, and there's this idea of a breach of contract, and the department characterized a contract very broadly as including your catalog and bulletins and all these kinds of things. You know, I think even if you're a private nonprofit or a public institution, you know, you may have different types of agreements with students to use facilities, athletic facilities, to participate in different types of events. And ostensibly, If you have someone who received or benefited from a direct loan, I think if you were to try to include a pre-arbitration dispute agreement in one of those, you could potentially run into this rule. Any future agreement, so this is regarding the mandatory language, any future agreement with a student who received or benefited from a direct loan that includes a class action waiver would have to include this clause. Right? We agree that neither we nor anyone else will use this agreement to stop you from being a part of a class action lawsuit in court. I'm not going to read the rest. It basically carries out that same sentiment in various aspects, right? But you would have to include this clause in any future agreement. With regard to any existing agreement you might have that includes a pre-dispute, and by the way, I should say pre-dispute, it's important to note the department is not prohibiting schools from entering into a post-dispute arbitration agreement with a student. So in other words, once the dispute has arisen, if you were to go to a student and you were to say, hey, would you be willing to enter to an arbitration agreement that would sort of set out the terms by which we agree that we're going to do this through arbitration, you could do that. Right? This is only about pre-dispute arbitration clauses. So we're talking about at the time of enrollment, for example, before something ever comes up, if you include in your enrollment agreement, we agree now, before any dispute has arisen, that we will go through arbitration if something should come up. That's what the department is getting at. So in any agreement, enrollment agreement or otherwise, where you may already have one of these pre-dispute arbitration clauses, addressing class actions, in this case, I'm sorry, I'm getting ahead of myself, we're really specifically talking about the class action waivers. You would have to amend the language of that agreement to include some specific CAN language that the department has in the reg, which looks a lot like what you saw on the prior slide. Or alternatively, you would have to distribute a written notice to each of these students specifying that the school won't seek to prevent a class action, and that notice also would have to include certain CAN language. In both cases, again, the school is going to have to use the specific language that the department has included in the reg. We don't have it here. We didn't want to gum up all the slides, but it's pretty easy to find. Schools are prohibited from, so the first piece here, we were talking about class action waivers, and now we're talking about the pre-dispute arbitration clauses. The mechanisms the department has put in place and the way they're approaching these are pretty much the same, right? So schools are prohibited from entering into a pre-dispute agreement to arbitrate a qualifying claim or relying in any way on a pre-dispute arbitration agreement. Similarly, as you recall, you're prohibited from entering into a class action waiver or relying on a class action waiver. A pre-dispute arbitration agreement means any agreement, regardless of its form or structure, between a school or party acting on behalf of a school and a student providing for arbitration in any future dispute between the parties. The other thing that I want to highlight here is if you were to go back to the proposed regs or to our prior presentation and look at the slides, you would notice that originally in the proposed regs what the department prohibited was schools from compelling a student to enter into a pre-dispute agreement. And there were a number of mainly sort of victims' rights advocates and folks on that side of the house that in the comments to the proposed reg said, well, this makes it sound like if you're not actually compelling someone and if they just agreed, you wouldn't be subject to this rule. So the department actually revised the language to make clear, you know, there isn't some requirement that you're compelling someone or forcing them under duress. We're just going to make it very clear that schools are prohibited from simply entering into a pre-dispute agreement, right? So in this case, they sort of broaden the meaning of the rule. This is the mandatory language that you would have to include in any future enrollment agreements or other agreements with a student regarding pre-dispute arbitration. And you'll see it says, we agree that neither we nor anyone else will use this agreement to stop you from bringing a lawsuit concerning our acts or omissions regarding the making of the federal direct loan or the provision by us of educational services or which such loan was obtained. And of course, that's sort of the definition of a bar defense claim, or at least in part what would be the basis of a bar, be required for a bar defense claim. Similarly, with regard to existing enrollment agreements or contracts you may have with a student, once again, you're going to have to go back and either amend that language and include in that agreement a new clause that the department has put in the regs, basically saying that you won't enforce any type of pre-dispute arbitration clause, or once again, alternatively, you could reach out to all of those students and provide them with a notice essentially saying the same thing. So lastly, and then I'll turn it over to Jeff, qualifying claim notification. So this was the notification requirement I mentioned. Going forward, and again, this is not specific to proprietary schools. Institutions must notify and provide documentation to the department if a matter involving a qualifying claim is filed in arbitration or court. So any school private, nonprofit, public, or proprietary, if you receive a claim that is, in this case, what we're calling a qualifying claim, so something that could be or give rise to a bar defense claim, you've got to report that to the department. And the requirement applies that the claim is filed by or against the school. So interestingly enough, it's not just as someone suing you. If in theory you wanted to sue someone else over one of these matters and you filed the claim or filed an arbitration, that would also trigger your reporting requirement. For litigation, the requirement is you have to notify the department within 30 days. So again, if you've got outside counsel managing your litigation in such matters, or you've got in-house counsel or compliance officers doing this kind of work, you're going to have to be coordinated with them, and they need to be aware of this, because if you're in the financial aid office, you will probably not be the one served with litigation, right, or have notice of such a claim. So this is going to require more integrated coordination among different, what I'll call sort of verticals of the institution. All right, so with that, we're on to the question of legal authority. And I'll turn it over to Jeff.
Well, hello. It's unclear whether the department has any authority to ban schools from using or enforcing pre-dispute arbitration agreements with students. As a way of background, several congressional agencies, including the Department and the Center for Medicare and Medicaid Services, has been encouraged by legislators, mostly on the Democratic side, to try to restrict arbitration in entities that they regulate. These legislators were unable to get Congress to change the Federal Arbitration Act, and so instead of trying to change this legislatively, what they have done is try to get the various federal agencies to issue regulations to restrict the use of arbitration. By way of background, the Federal Arbitration Act, which has been around for almost 100 years, says that pre-dispute arbitration agreements are generally valid and enforceable. And the FAA implements a strong federal policy favoring arbitration of disputes. And within the last 10, 20 years, the FAA has been vigorously enforced, and some would say expanded, by the United States Supreme Court. I mean, not only do they say that arbitration was binding and you have to do it, but they also said that you could effectively prohibit class actions by requiring consumers or other entities to arbitrate, and to arbitrate on an individual basis and not through a class action. Now, a lot of those decisions were 5-4 decisions, and with the passing of Justice Scalia, there was some question as to what would happen going forward in the U.S. Supreme Court in cases involving the Federal Arbitration Act, depending on whether you got a justice who is more liberally inclined or more conservatively inclined. Given the election and President-elect Trump's promise to elect or nominate a new justice in the mold of Justice Scalia, it appears that the Federal Arbitration Act will continue to have a strong effect in terms of consumer disputes, just as it has been given the last 10, 15, 20 years. Now, in this case, in the rule barring pre-dispute arbitration agreements with students, the Department of Education has conceded it doesn't have authority to displace or diminish the effect of the Federal Arbitration Act. But yet, the department claims that it can effectively, if not directly, bar pre-dispute arbitration agreements that would otherwise be enforceable under the Federal Arbitration Act. And why does it think it does that? Well, it concedes that it has no express authority from Congress to regulate arbitration, and that the Higher Education Act is silent about it. But they think, because they think arbitration is disadvantageous and harmful to both students and in turn to the department, that it can force educational institutions to accept a ban on arbitration as a condition of participation. As we know, the Higher Education Act is silent about arbitration. And that's important because if you compare that, there are other statutes out there enacted by Congress which expressly say that other federal agencies can regulate arbitration agreements within their field. And the biggest example is the Dodd-Frank Act, and that gives authority to the Consumer Financial Protection Board to regulate arbitration agreements and consumer financial agreements. And the CFPB has issued rules which are about to take effect in that field. And there's really no doubt in that the CFPB has authority to regulate arbitration because Congress expressly said they could do so. Now, the implicit authority that the Department, it's under 28 U.S.C. Section 1087D-A6. As we mentioned, this is a very vague provision. It basically says, Department, you can put into your program participation agreement provisions that you think are necessary to protect the interest of the United States and to promote the purposes of this part of the United States Code. Then they say, look, this is the Department's position is that, look, we need to get rid of class action waivers and we need to get rid of arbitration agreements because they, quote, substantially harm the financial interest of the United States and thwart achievement of the purpose of the direct loan program. And what the Department is trying to say here and argue is that through arbitration, and especially class action waivers, schools are inoculating themselves. They're keeping themselves from being accountable for their misconduct. And it's discouraging students from trying to hold schools accountable, which in turn hurts the government because then these students complain and say, I was defrauded and I don't want to have to pay my student loan. And that, in fact, shifts the risk of loss on the student loans to the taxpayer. Now, so the ED claims this implicit authority under Section 1087. I don't think it's really ever thought through, though, is that implicit authority limited by anything, or is it just a blank grant of authority to do whatever it wants? It's pretty clear from case law, though, that regardless of what implicit authority you have under any federal statutes, you cannot issue rules that violate other federal statutes. And here, the big federal statute that the Department is arguably violating through its rule is the Federal Arbitration Act. And you think by definition when the ED is given authority to include provisions that are necessary to protect the interest of the United States, well, the interests of the United States are defined by the other federal statutes that Congress has enacted. And one of those statutes is the Federal Arbitration Act. The Federal Arbitration Act, as we've discussed, emboldens a strong federal policy for arbitration. And the idea is to shift disputes and the burden of resolving these disputes from the federal courts into private arbitration. And so it seems the conclusion should be is that, hey, if you put a provision in a program participation agreement that conflicts the Federal Arbitration Act and discourages arbitration, that's not really necessary to protect the interest of the United States. Just the contrary, it's against the interest of the United States. Because while the Department of Education might like it, well, the federal courts might not like it because it'll bring a flood of claims to the federal courts that would otherwise, or into state courts, these claims would otherwise be resolved in arbitration, which is what Congress is intended and when it enacted the Federal Arbitration Act, I said many, many decades ago. So it looks like that an effective ban on pre-dispute arbitration agreements would violate the Federal Arbitration Act. Now, there's been no ruling on this yet because this is a novel issue, but it's a hot issue in a couple other fields. As I mentioned before, other federal agencies have been trying to ban the use of arbitration within the industries they regulate. And two industries in particular where this is front and foremost is in the nursing home industry and with the National Labor Relations Board, the NLRB. Recently, we have the Center for Medicare and Medicaid Services at CMS issued a rule prohibiting nursing homes that participate in Medicare or Medicaid from entering into new pre-dispute arbitration agreements with their residents. There are nursing home groups that challenge this rule, and just recently, about a month ago in November, a federal district court in Mississippi issued a preliminary injunction barring enforcement of the rule for now. Now, because it's a preliminary injunction, it's not a final judgment or a final ruling, and then even that, it could go up on appeal to the Court of Appeals and perhaps the United States Supreme Court. But at this time, this federal district court in Mississippi made a preliminary finding that CMS does not have the authority to ban nursing home arbitration. And interestingly, most of the arguments advanced by CMS in defense of its arbitration ban in nursing homes are almost the same as what the Department of Education is doing in issuing its rule barring arbitration in enrollment agreements with students. In the CMS case, the nursing homes, CMS argued that it had authority because Congress had authorized the Secretary of Health and Human Services to issue, quote, such other requirements relating to the health and safety and the well-being of residents as she may find necessary, and to establish other rights to protect and promote the rights of each resident. Now, it's not exactly the same language that we have in Section 1087, but it's very similar. And similar to what the Department's relying on is its authority to include in program participation agreements, quote, such other provisions as the Secretary determines are necessary to protect the interests of the United States. Both of these are very vague provisions and seem to give a lot of authority to the respective agencies as to what the regulations say. But in the nursing home case, the federal court in Mississippi disagreed with CMS and said, quote, seeking to ban nursing home arbitration agreements on the basis of extremely vague language such as this represents a breathtakingly broad assertion of authority by a federal agency. And the court also observed and noted that, quote, a serious danger that if generalized language were deemed sufficient to authorize a ban on arbitration agreements in nursing home cases, then many other agencies would choose to broadly exert power in a variety of contexts. The court was concerned here is that if you get a vague provision like this, go out and do whatever you want that you believe is in the interest of the United States, that would open the barn door to agencies doing whatever they want, whether it was consistent with other federal statutes, contrary to other federal statutes. So I think the court in the nursing home cases was very uncomfortable with this idea that this vague language was an invitation to CMS to somehow bar nursing homes from using arbitration agreements with their patients. The court also noted, as we kind of touching upon the theme earlier, that when Congress wants to authorize a federal agency to be able to regulate or prohibit arbitration, it usually does so in clear and direct language, just as it did in the Dodd-Frank Act. And in this case, the court noted, hey, there's no such authority granted to CMS. And then the next important point kind of draws a parallel to what the Department of Education is doing. The court rejected CMS's argument that the arbitration ban for nursing homes was valid because their participation in Medicare and Medicaid is, quote, voluntary. That's an argument that the ED has raised here is that, hey, you don't have to participate in the Title IV program. If you want to enroll students without federal financial aid, you're welcome to do so. But in the nursing home cases, the court said, well, wait a minute, this isn't really a voluntary system here because nursing homes are heavily dependent on Medicare and Medicaid funds. I mean, most nursing home patients are Medicare or Medicaid beneficiaries, and if you say this is voluntary and that you, the nursing homes, don't like what the CMS is doing, you can just drop out of the federal programs. That doesn't cut it because that's really not a voluntary participation given how dependent the nursing homes are. So you have the argument that the CMS raised, that the ED is raising, same here. In several respects, one is that they've got a broad authority under this vague provision, and second, that they're really not necessarily, quote, banning it directly. They're just doing it indirectly because they're doing it under their spending authority. The federal court in Mississippi, at least in the nursing home context, has said, well, that's not going to cut it. You, the federal agency, don't have the authority to ban arbitration on those bases. Now, it'd be interesting to see whether that carries over into with the Department of Education. Now, the other context where we've seen this dispute over the authority of an agency to regulate arbitration is with the NLRB. And these cases have been percolating for many, many years. And what's happened is the National Labor Relations Board has been deciding consistently, case after case, that employers can't have arbitration agreements with their employees that ban class action claims in arbitration. They believe that's a violation of employees' rights to collective action. The first court to really address this was the Fifth Circuit, and the Fifth Circuit has struck down the NLRB's decisions because, in its view, the National Labor Relations Act is silent about arbitration and doesn't override the FAA. It's, again, this idea that if your governing statute as an agency does not expressly give you authority to regulate arbitration, we're not going to find that you have implied authority to do so, especially when Congress has given express authority to other agencies to regulate arbitration. The NLRB has had an ongoing dispute with the Fifth Circuit, and this circuit has ruled twice now that the NLRB cannot preclude employers from enforcing class action waivers on their employees. The NLRB has refused to acquiesce in the Fifth Circuit's decision and keeps issuing rulings saying employers violate the National Labor Relations Act if they try to ban or try to enforce class action waivers with their employers, or their employees, excuse me. Now, there's been a dispute on this. Other courts, notably the Seventh and Ninth Circuits, have upheld the NLRB's decisions on the basis that the National Labor Relations Act prohibits employers from interfering with collective action by employees, and that by banning class actions by their employees, they're interfering with those rights. This is one of those issues that is in limbo, and in each of these cases, in the Fifth Circuit, the NLRB, and in the Seventh and the Ninth Circuit, the employers have all requested that the United States Supreme Court take up the issue and resolve it. And it seems, given the conflict between the different circuits on this issue, it seems it's going to go up there. And in fact, this could be the one case that you get some broad announcement of authority from the U.S. Supreme Court that would affect not only the NLRB, but affect other federal agencies, such as the Department of Education, in terms of what they can do in regulating arbitration. So we'll go on to the meantime as to what arbitration agreements should have in them for best practices, assuming that you can continue to do so, and you'll be able to. If you have a class action waiver or a pre-dispute arbitration agreement, you should monitor CRA and agency activity closely. And it's very important, thinking through this, that even if it's not being enforced by the Department of Education, if the rule is still on the books and hasn't been challenged, hasn't been struck down, it's a rule you're going to have to comply with because, one, if you try to enforce your arbitration agreements, you're going to have plaintiffs' lawyers or lawyers for students will say, no, this arbitration agreement's unenforceable under the ED's rules. And secondly, there's also a risk if you continue to try to enforce arbitration and contrary to the rule that's on the books, you could subject yourself to possible liability under the False Claims Act. So that's something to keep in mind. And as we discussed before, but keep in mind that the new rule does not ban all arbitration agreements. I mean, even if the rule sticks, schools may determine to keep limited arbitration agreements in place. And the biggest example is you can do it for students who are not participating in the federal financial aid programs. There's no ban on that. So in the meantime, the regulations don't bar schools from seeking to persuade students to agree to arbitrate so long as the attempt is made after a dispute arises. So that means if you've got a dispute, a student comes in and says, I think you misled me, the school could try to convince the student to arbitrate and say, hey, this is a cheaper way to go. Why don't we submit this to arbitration instead of litigation? Typically, though, in my experience, students, and especially attorneys who represent them, try to avoid arbitration at all costs if they can. They'd much prefer to be in court and have a jury, maybe try to assert a class action. So while in theory, schools can try to persuade students to arbitrate, chances are it's not going to happen, especially if the student's already engaged an attorney to represent him or her. Now, as I said, the regulations extend only the pre-dispute agreement to arbitrate borrower defense type grievances. So if there's stuff that's not a borrower defense related grievance, you could still enforce arbitration as to those types of grievances. And as Aaron said, a prototype example of that would be a slip and fall. However, pretty much in my experience, most student claims are going to involve some kind of misrepresentation by the student or by the school or some kind of breach of contract by the school. And generally speaking, those kind of disputes involving alleged misrepresentation or breach of contract are going to qualify as a borrower defense-related claim. So with regard to your existing arbitration agreements or any agreements you may design in the future, continue to follow best practices. Outside of the Department of Education rule trying to ban it, there's a wide body of law that varies from state to state, but generally has some recurring themes in terms of trying to keep your arbitration agreements enforceable. First of all, you got to make sure that you have the student's assent on the agreement. It doesn't mean that they have to like it or that they prefer it, but you do have to make sure you have their agreement to the arbitration provision. And this comes up in cases I've handled where students will say, no, yeah, that's an enrollment agreement, but hey, I didn't sign that. I didn't agree to that. And you really want to avoid disputes about whether a student agreed to arbitration. And at least in my experience, getting a student's wedding signature on the agreement is by far the best remedy to that. Electronic signatures are used a lot in documents. I know a lot of schools use them. But based on my experience, they often are disputed. Even if the agreement says got a little name on the student's type name on it, the student will say, wait a minute, I didn't sign anything, I didn't do it. Or they'll claim that the financial aid person or the admissions representative did whatever it took to complete the electronic signature in the school's computer system. So a wet ink signature is best if that's feasible to do, and you don't necessarily have the wet ink signatures on every document that a student signs, but I highly recommend it on the enrollment agreement. Next, after you make sure you have the student's assent to the agreement, you need to make sure that the arbitration agreement is mutual. In many states, courts are only going to enforce arbitration if both the school and the student have to arbitrate any claims between them. Sometimes we've seen this. A school may try to reserve some claims and say, well, I want to be able to go sue the student for certain kinds of claims. Perhaps the student owes me money. I want to be able to go to court and sue them because maybe I'll do it in a small claims court and it's a lot quicker. If I go to court, I'll get maybe a default judgment or a consent judgment. I'll get something really quick, and I don't want to deal with arbitration when I'm trying to collect money from the student. The school tries to do that and reserves it so they can litigate some claims while trying to make the student arbitrate all of his claims. A lot of courts will not enforce that and say there's no mutuality there. I'm not going to force students to arbitrate. So a school cannot retain a unilateral right to change the arbitration agreement. And you got to be careful here, because what we've seen in some cases is that you'll have your enrollment agreement seems crystal clear, solid, but then it might incorporate a document, such as a school catalog. And the school catalog, as we might expect, is going to be changed from time to time. And so I've seen arguments made, well, you have the right to change your school catalog, which becomes a part of the enrollment agreement, and by reserving that right, you can change the arbitration agreement in the enrollment agreement. And because you can do that, the arbitration provision is illusory, and courts are not going to enforce it. So that's one risk there, is just to make sure that the arbitration agreement and the enrollment agreement is locked tight, and it cannot be changed unilaterally by the school. And additional best practices with your arbitration agreements. You can, in your arbitration agreement, apportion expenses of the arbitration. And arbitrations sometimes are not that cheap. It's a fairly significant expense to pay for the arbitrator, because you're basically paying for an attorney for his time, usually on an hourly or a daily rate. You're usually talking several thousands of dollars. And you can try to split that cost between the school and the student. If the expense, though, is deemed to be excessive to the student, if courts think that you're trying to charge too much and shift too much of the cost to the student, there's a chance they'll find it on your arbitration agreement to be unconscionable and may not enforce it. So courts are more likely to enforce your arbitration agreement if the students are not required to pay significant expenses to arbitrate, that meaning the arbitration, filing fees, and the arbitrator compensation. I've seen in some enrollment agreements what we'll do is they'll say you, the student, only have to pay how much you would have to pay to file a lawsuit in federal or state court, whether it's $100 or $200 or $300, and anything beyond that cost that's incurred from the arbitration, we, the school, will pick it up. That will enhance your ability or enhance the likelihood that your arbitration agreement will be found to be enforceable and won't be found to be unconscionable. And then if you want to avoid class action claims in arbitration, you should really spell it out clearly in the arbitration provision that the student cannot bring a class action claim in arbitration, can't bring a collective action, can't bring a representative action. Now, U.S. Supreme Court precedent has been that if the arbitration provision does not authorize class actions, you can't have class actions in federal court. But I hate to rely on that. I'd rather have, agreements typically do say this, is that you'd rather have it in black and white that the student cannot bring a class action or any kind of representative action in arbitration. And with that, I will turn it back over to Aaron, who's now going to discuss the new repayment rate.
Thanks, Jeff. Much appreciated and very educational for me, certainly, among others, I hope. So the new repayment rate, new in quotes because, as it turns out, it's really not so new. So where the arbitration and class action provisions changed very little from the proposed rule to the final, the repayment rate framework changed dramatically. So first of all, at the top, the department scrapped the repayment rate formula that was in the proposed regulation. And you will recall they were using a methodology that was different from the methodology used for the gainful employment disclosure repayment rate, and also different from the methodology used for the college scorecard. It was going to be a new and distinct third federal repayment rate. And as you can imagine, many people expressed dissatisfaction with that arrangement in their comments to the department. You know, the department, as you would expect, did not roll over in terms of how it explained its decision, but ultimately the determination was made and it agreed. And I've got the quote here from the Federal Register: to avoid any confusion resulting from a new repayment rate calculation, as well as to limit the burden on institutions, we are revising the repayment rate provision. Under this revised provision, the repayment rate data that proprietary institutions report at the program level, and this is for purposes of GE, will be used to calculate a comparable repayment rate at the institution level. So, in other words, the department's going to calculate an institution-level repayment rate for you using the same formula and the data that it is already using to calculate the program-by-program repayment rates for your GE programs. So here's the calculation. It's found at 668-413B3. You see we've got the citations in the lower left-hand corner for you. And again, this is the formula that is used, and it's in the gainful employment section of the regulations, and it's the formula that's used to calculate that program-by-program repayment rate, and here they're just changing it to incorporate and be calculated at the institutional level, so it incorporates all your GE students. So it's the number of borrowers paid in full plus the number of borrowers in active repayment divided by the number of borrowers entering repayment. You may already be familiar with this formula if you've thought about it for purposes of GE, or maybe not, so I wanted to give you a little more detail. Of course, $1 million question when you look at this is, well, what does it mean to have a borrower in active repayment, right? Because certainly you would expect to get credit for anyone who's paid in full. But there's some question as to what it means to be in active repayment. All right, so here's the numerator. Paid in full is exactly what you think. That's the folks who've fully repaid all their FFEL direct loans. Number of borrowers in active repayment means of the number of borrowers entering repayment during the cohort, the ones who during the most recently completed award year, and again, this is a difference also from what was proposed in the proposed regs. Remember there they had this 3-, 4-, 5-year span, and they were looking at who had paid down at least $1 over, you know, looking at the difference between when they entered repayment and 5 years later. Here, what they're doing is they're just looking at the folks who entered repayment during a 2-year cohort period, right? And it's the same 2-year cohort period, by the way, that applies for all your GE, for your debt-to-earning rate calculations, et cetera. So for this first time around, if these regs were effective right now, for example, you know, your debt-to-earnings rates under the gainful employment metric are being calculated for the 14-15 award year, and they're looking at folks who graduated in 10, 11, 11, 12. So if this repayment rate formula were already in effect, what we'd be looking at is people who entered repayment in 10, 11, 11, 12. And of those folks, we'd want to see during 14, 15, well, actually, technically 15, 16 is the most recently completed award year because the department's so far behind, but it would be 14, 15, right, of those folks who made loan payments sufficient to reduce by at least $1 the outstanding balance. So if you've got folks in income-based repayment plans and they're in negative amortization and they haven't paid down their principal at least $1, right, then they're conceivably going to not be considered an active repayment, right? This includes consolidation loans that include FFEL direct loans. And what they do is, to be clear, they're comparing the outstanding balance at the beginning of the award year, not at the point at which they entered repayment, with their balance at the end of the award year. That's how they're doing it. So theoretically, you know, we're looking again at folks who entered repayment 10, 11, 11, 12. You could have had someone who made no payments on their loans or even fell behind in those first few years, right, 13 or 14, right? But when they got to the 14, 15 award year, if they had managed to pay down their outstanding balance, then now they would be considered an active repayment. So it is very different from that repayment formula that was proposed with the proposed regs, right? Here it looks just like, again, it's your gainful employment repayment formula. But the critical point I'm trying to make is just because somebody is actively making payments over the award year who's in the cohort, if they haven't managed to reduce their starting balance from the beginning of the award year by the end of the award year for some reason, then you're not going to get credit for them, okay? The number of borrowers entering repayment, this is your denominator, the total number of borrowers who entered repayment during the 2-year cohort period on FFEL or direct loans received for enrollment in the program. So that's what you would expect. All right, so what's the warnings trigger? The school has to make, and by the way, this is the sanction here. The risk for institutions under the repayment rate framework is that you have to make a student warning. So there is no risk to your eligibility. There is no risk to your, letter of credit amounts or your financial responsibility with the department, no immediate risk anyway. The whole kit and caboodle here, the only sanction is that you have to make these warnings. I'm not suggesting that that's not significant or that it's, wanted. Certainly it would be unwanted and could, of course, have a detrimental impact on enrollments, things of that nature. But relative to the other components of the bar defense rulemaking, we would consider the risk piece here to be much lower. The school must make the warnings if its institutional repayment rate is less than 50%. I mean, that's it. Now, the department has expressed this in a really odd way in the regulation. They say warnings must be made for any award year in which the institution's loan repayment rate shows that the median borrower has not either fully repaid or made loan payments sufficient to reduce by at least $1 the outstanding balance of each of the borrower's FFPL direct loans. What's confusing here is the median borrower in the context of when you're calculating debt to earnings rates, for example, for gainful employment, what you're doing is you're stacking up all your borrowers and you're looking at their median debt and you're finding the person who's got the debt number is the median number, right? The median borrower here is not the debt number. What they're doing instead is they're looking at how much people have paid down on their debt, and that's what would be if you were imagining, a spreadsheet where you had all these people listed in a column in order of how much they had paid down, from someone who's paid back, $10,000 over the award year to all the folks who are at zero down at the bottom, and they're finding the median person on that list. So this isn't median debt. Even though you're still talking about, quote, a median borrower, you're talking about the median in terms of the amounts that have been paid back over the course of the award year, which is confusing. And the other point to make is it's not even clear to me you would have to calculate a rate here. I mean, really, what you could do is you could just determine the amount all these folks have paid back and then take that pool and look at the median borrower, right? And then you just determine if that person's fully repaid or made payments down. If the person in the middle is zero or negative, then you've got your answer. You have to start making the warning. And this is sort of reflected in the fact that the disclosure you have to make, it's on the next slide, actually, I'm getting a little ahead of myself, but you don't actually have to disclose your institutional repayment rate. That's not something that actually has to be disclosed. So it's interesting, they're going to calculate this rate. And one way of thinking about it is, like I expressed on the prior slide, and keeping it simple is just if your institutional repayment rate is less than 50%. That's when you have to make the warning. But really, the regulatory language doesn't key on the rate itself. It keys on whether or not your median borrower has, in fact, made any payments. So, I don't know. It's sort of odd the way they went about approaching that. So in terms of distribution, you have to include the warning in all promotional materials that are made available to prospective or enrolled students by or on behalf of the institution. So remember, if you've got a third party out there that's creating microsites or generating collateral or marketing materials for you, ostensibly the warning would have to be included in those as well. As you know, promotional materials, the department from the beginning, way back in Gainful Employment 2011, they've taken a real broad view of this concept. So it's not just your marketing, it's your websites, catalogs, invitations, flyers, billboards, advertising on radio, television, video, social media, or the internet. So they want it pretty much everywhere. Significantly, it's in a tiny bullet here at the bottom, but this is an important point. The department dropped the requirement for direct distribution to current and prospective students. So here, the warning distribution is limited to promotional materials in the final rule. Now, before you say, oh, what a win, the reason they did that is because, remember, you're still having to calculate a program-level repayment rate. And you're going to have to make your program-level repayment rate disclosure to all those students, likely in the context of the Gainful Employment Disclosure Template. So if you've got a really bad repayment rate or a low repayment rate that's been calculated for the program, the department's view is, well, that's already being disclosed to prospective and current students, so there's no reason necessarily to make schools disclose this other rate. So what is the warning itself? The reg says the warning language must read, U.S. Department of Education warning, a majority of recent student loan borrowers at this school are not paying down their loans. The department indicates that it may conduct consumer testing to determine whether or not this disclosure really makes sense, or they want to change up the wording, and if they do decide to change up the wording, they would put that out in a forthcoming Federal Register. Okay, so I just have a couple of 3 more slides left for you here. You know, one of the big issues I think that came up in the context of this whole, you know, new payment rate for the proprietary sector was, what is the basis for singling out the proprietary sector? And is there really a valid justification? I will tell you that the response, so the department addressed this in the preamble and they talked about it, and I will tell you that their response was largely predictable. As most of you know who spend any time really thinking about this or looking at some of the underlying data, the truth is it can be cut in a lot of different ways, right? And depending on how you want to characterize the different statistics and data that are out there, you can make it look like the proprietary sector is particularly bad, or you can certainly make good arguments that the proprietary sector is really not that far off from other folks. Certainly there are arguments to be made that if you were to calculate numbers instead of by ownership structure, but by repayment demographics or geography or the type of programming, you would probably see maybe even better data or something that's even more illuminating. You know, my advice is if you really want to see all the department's arguments, you can go read the preamble, although if you feel strongly about this topic, I would suggest before doing so that you pour yourself a nice drink and put on some holiday music because you're not going to see things that you agree with. I will tell you that right away. There were at least a couple of choice comments, though, that I just could not resist from sharing with you all. So the first is this, and again, this is in the department's argument, you know, sort of reply in response to those who said there's no good basis to single out the proprietary sector. So the first thing the department said was, or the first thing that I have highlighted, the department believes that because of the changes to the repayment rate, so in other words, because of the changes they've made here by throwing out this new type of repayment rate and instead relying on the gainful employment methodology, it would be inappropriate to apply an institutional warning to sectors other than the proprietary sector because public and private nonprofit institutions are not typically comprised solely of GE programs. And the repayment rate warning may not be representative of all borrowers at the school. So I thought this was a wonderfully novel argument. In other words, the department has created this gainful employment regulation, and as you all know, the way that the regulation has been designed, every program offered by a for-profit institution for the most part is a gainful employment program, and only non-degree programs offered by public and private nonprofit institutions are GE programs, even if they're identical programs at the two schools in every way, just by virtue of how the ownership structures are designed at those two institutions. And so what the department is saying is, well, now that we've decided to use the GE repayment rate, it just wouldn't make sense to extend this requirement to the public and private nonprofit schools because so many of their programs aren't GE programs and we're not getting the data. So I thought that was really sort of a novel take on things given that they were the ones that designed and designated what's a gainful employment program. But this was absolutely my favorite, and I think it really illustrates how, two things. One is how easy and dangerous it is for all of us, including federal agencies, to manipulate data and try to present it in the ways that we want to justify our arguments. But the other thing, too, is how weak the department's arguments really are here. Because if they had good arguments, I can't imagine that they would expose themselves with something like this. So the department said, again, in its justification of why this shouldn't apply to all sectors, federal student loan borrowers also typically represent a relatively small proportion of the student population in the public sector, whereas borrowing rates are much higher on average at proprietary institutions. For instance, among full-time undergraduates enrolled in 2011-12, 19.7% borrowed Stafford loans at public less than 2-year institutions, compared with 82.9% at for-profit less than 2-year institutions and 83.3% at for-profit 2-year and above institutions. Okay, so this is the last slide of the presentation. This is my Christmas gift to you. If you haven't figured out what to send your Republican friends or Republican congresspersons, you can take this slide and mail it to them. So on the left, I've got the department statement again, or at least the first part of it. Federal student loan borrowers also typically represent a relatively small proportion of the student population in the public sector, whereas borrowing rates are much higher on average at proprietary institutions. Now, the first question is, of course, why is the department in this statement not including private nonprofit institutions, right? I mean, they're only applying this rule to the proprietary sector. So you would think they would feel the need to justify why it should not apply to both public and private nonprofit institutions. But in making the statement, they have only singled out public institutions, right? Well, the first thing you'll see is at private nonprofit. By the way, this data, so when the department cited its data, it gave the citation to these statistics from NCES. So we pulled them up and took a look at them, right? If you look, the 3 boxes in yellow, those are the 3 numbers that the department decided to highlight. Less than 2-year public institutions, 19.7%. And then at private for-profit institutions, you see the two, 83.3 and 82.9. Again, the department completely ignored the private nonprofit sector, despite the fact that they are also essentially choosing not to apply these rates or this repayment rate construct to the private nonprofit industry. And the basis and part of their argument is essentially lots more people take out Stafford loans at private for-profit institutions. It's a much higher number on average than at public and private nonprofit institutions. So first of all, let's look at the public. That's at the top, right? So less than 2 year. That's the 19.7% that the department cited. Okay. There are roughly 6 million students. This is from 11-12 data. There were roughly 6 million students in the public sector, and the department decided to use the rate that was applicable to 31,000 of those students out of 6 million. But if you look, obviously, at 4-year doctoral and other 4 years, so basically every public institution where they have a bachelor's degree or higher, right, that the average percentage of borrowers is much closer to 60%, right? But the department, instead of choosing the 60%, chose the 19.7. Overall at public institutions, borrowing of Stafford loans is at around 47%. Now, the department characterized this as a relatively small proportion. I would suggest it is very hard for that characterization to hold water, right? It's extraordinary to me, frankly, that they would go with the 19.7 when that is, again, 31,000 of the 6 million students at public institutions. There again, they totally ignore the private nonprofit numbers, and you'll see that among private nonprofit students, it's 66% that are borrowing across all sectors. And if you look at the 4-year, it's even higher than that, right? It's closer to probably 64, 65% across those two. So I found this amazing. But the other thing that's worth noting, and the reason I included the last column out to the right, is how many borrowers you're talking about in absolute numbers, right? I mean, the department is choosing to exclude all public and private nonprofit borrowers. And if you look, you've got 6 million in the public sector and nearly 2 million in the private nonprofit sector, as opposed to about 1 million in the private for-profit sector. So just, I ran these numbers and did a little math on my napkin here, and that's 83% of all Stafford loan borrowers are either at the public or private nonprofit institutions, with only 17% at proprietary. So, you know, they're making this argument that part of the reason you would only focus on the for-profits is because there are so many more people borrowing federal loans. But the truth of the matter is the numbers are not nearly as far apart as the department would suggest, right? And there are lots more actual borrowers in the public and private nonprofit sector. So if those folks are indeed at institutions that have poor repayment rates, it begs the question, why would we be excluding them? They're borrowing at pretty high levels, just like at private for-profits, and there are a lot of students who could be affected. In fact, the real numbers of students that could be impacted by institutions with poor repayment rates in those sectors could well be higher. I want to emphasize here at the end, because you can probably hear that I'm almost giggling. You know, the fact of the matter is the highest numbers are still in the private for-profit sector. I mean, there's no doubt about that. But the argument the department is making and they're trying to defend isn't that all students shouldn't receive this repayment rate information. I think that's a different argument, right? And maybe they already do. Maybe we still don't need a third repayment rate. I mean, but that's a different set of discussions. The thing that is incredible to me is that they are trying to base this on this notion that there is a much higher level of borrowing among private for-profit institutions, and that seems to be actually inaccurate based on the same data set that they used to justify the original argument. Here we've got TC resources. We've got our blog. We're always happy for you to check it out. We write about a lot of this stuff and hope to be writing about more in the days to come. And then that's the contact information for Jeff and for myself. So with that, we'll look at some questions. The first one, I think we've addressed this, but the question was prohibited from relying on. So talking about that language in the rule that prohibits you from relying on class action waivers or relying on arbitration provisions. The questioner says, so prohibiting from relying on means we can have arbitration language in the agreement if we include qualifying language that applies to students who benefit from direct loans, which will apply to students who don't benefit from direct loans. So I believe I understand the question, and we sort of got at this earlier, but the answer, to be very clear, is yes. You could still have an arbitration clause or a class action waiver clause in your enrollment agreement, and it would apply to everyone insofar as you're talking about slip and falls or any other type of claim that's not a borrower defense claim, and it would still apply to individuals who do not receive any type of direct loan in all circumstances. What you cannot do under the new rule is include a pre-dispute arbitration agreement or class action waiver for individuals who receive direct loans and when you're talking about a claim that is a qualifying claim, which essentially means something that could give rise to or is related to a borrower defense claim. The department in the preamble used the phrase, borrower defense type claim. Do we have to notify the department? So talking about these notification requirements, if we file a collection action against a student who benefited from a direct loan, even though the amount to be collected is tuition and fees not paid by a direct loan. I think this is less about what you're trying to collect and more about whether the department would consider a collection action to be a borrower defense claim, and I'm going to pitch this to Jeff because I'm interested in his thoughts. I mean, my gut is I don't think the department was really thinking about collection actions. I think it was more concerned about making sure that if you were trying to compel to arbitration, it would know in a borrower defense style claim. But I will say, as a technical matter, an amount owed to you under an enrollment agreement is ostensibly, related to the educational services that were provided, and funded in part by the direct loan. And it ostensibly is pursuant to a breach of contract claim, I would think. But again, Jeff, what do you think?
Well, my take on it is that your notification is triggered if there's a borrower defense raised in a proceeding, whether it's an arbitration or a lawsuit. Initially, if a school files just a simple collection action against the student, at that point in time, there's really no borrower defense at issue. However, and you wouldn't have to notify the department. Now, if the student raises a borrower defense, either as an affirmative defense to your collection claim, or more likely, if they're going to do that, the student asserts a counterclaim against the school that claim qualifies as a borrower defense, at that point, the school would have to notify the department that there is a claim pending, either in a lawsuit or an arbitration, that involves a borrower defense, and so that the notice would have to be given to the department.
Yeah. Interesting. I don't know. We can talk about, I'm not sure, Jeff, if we're on the same page, because I feel like I think what the department's getting at isn't if they've actually asserted it as a borrower defense, but just if it's a claim that relates to or fits that definition of a borrower defense claim. Does that make sense? But I don't know. It's a great question, and I think part of the point here is this is still being figured out. What about electronic signatures using DocuSign? Jeff, this was really something you were talking about.
Yeah, I mean, we all know that there's several statutes on the federal level and the state level to give effect to electronic signatures on agreements. The idea is to encourage commerce done by electronic means. And really, those agreements and signatures using DocuSign are fully enforceable. It's really more of an evidentiary point and an issue in whether you use them or not on an enrollment agreement. Because even though you, the school, say, well, I know that the student signed it, I know they went on to the electronic signature process, went through all the steps, they indicated their assent to place their electronic signature, they made an electronic signature on the agreement, what can happen is they'll come back and say, no, I didn't do that. Financial aid rep did it, admissions representative did that for me without my knowledge or consent, they used my password or whatever, and you'll get an evidentiary dispute that is usually better avoided if you have a wet ink signature. And that's not to say a wet ink signature is perfect either. I've seen cases where the student will say, well, that's not my signature. Somebody must have signed my name on behalf of me. But in my experience, the likelihood of a signature being challenged on an enrollment agreement, it goes way up if the signature is done by electronic means as opposed to a wet ink signature.
Is this repayment rate the same repayment rate in the college scorecard? No, they're different methodologies. So the repayment rate used to calculate the gainful employment program level repayment rates, and I don't have the slide in front of me, but the citation is there to the gainful employment regs where that methodology is set out. It is different from the methodology used for the college scorecard, and the department has made information available on its website. I think you can get to it through the college scorecard website with regard to how those repayment rates are calculated. For repayment rate, does paid in full include those that are paid in full through consolidation? I think the department has made pretty clear, although consolidation is always a wrinkle when it comes to the calculation of repayment rates, and there can be issues with regard to determining what loans are in the consolidation loan and whether the underlying loans are in default or not. I've had conversations with folks who know a lot more about repayment rates and the methodologies than I do, and they've noted that there are limitations even in the department's own data that can make some of this very challenging. Some of that, I should note, was raised among those who were objecting to the proposed repayment rate that was originally in these regulations. But the point here is, in the regulations, they seem to make pretty clear that someone through consolidation, even though the underlying loans may be technically paid off, I mean, they're still going to be looking at whether or not, I believe this is what they are suggesting, is that they would still be looking at whether or not payments are being made on those underlying loans. So they would not be considered paid in full. I believe that is the answer, although I would be happy to run that to ground if someone wanted me to. What information does the warning regarding repayment rates to students include? So far, just that one sentence that was on the earlier slide, right, that said Department of Education warning. And again, they may do some consumer testing, they've indicated, to figure out whether or not they want to change that language or add to it. I just wanted to clarify, the institutional warnings needed to be posted due to a less than 50% repayment rate only applies to proprietary schools. That is correct. These rules, this is the only section of the rules in the whole bar defense rulemaking that specifically call out and only apply to proprietary schools. I do want to note, though, that the notification, all the arbitration stuff would apply to everyone, and that would potentially include or does include the notification requirements, right? Do we need to amend enrollment agreements with pre-existing arbitration clauses for students who are no longer enrolled? I would not do anything right now. I think one of our points was we think that a lot of this may be addressed in a CRA or through other mechanisms in the coming months. Even if nothing is addressed, this doesn't become effective until July 1, 2017. I have a couple of clients I chatted with, and my suggestion has been, let's sit tight, right? We don't want to start amending agreements and changing things until we know what's going to happen with the law. You know, we ought to have a good sense as to what's going to happen, you know, I would think by March or April, and by that point you've still got several months before the rule would take effect, which should be enough time to send out notices or augment agreements potentially. Is the department accounting for all forms of tuition payment when calculating these statistics? Could it be possible that many students at public and nonprofit institutions receive private grants and scholarships, thus reducing the need for loans, in addition to the state compensation for institutions? Many private, specifically career schools, don't have the scholarships or additional grant to offer students. Well, let me just take a big step back even from that and say, if you're talking about the statistics I put on the last slide relating to how many students take out federal loans, the first thing to note is that did not include Pell Grants. So there are even higher percentages if you start looking at the students at public institutions and private nonprofit institutions, in many cases, particularly public community colleges, that do get Pell Grants. But the bigger point here is, and I'm not saying this is a good or bad, and I'm not trying to point the finger, but it does undermine, I think, the point the department's trying to make, and most of, or many of you have heard this many times. And the fact is, you know, one of the reasons that you see a lower level of borrowing, particularly at public institutions, is because they are subsidized by state and local entities, and as a consequence, they have lower tuition. It's not because they have figured out a way to offer the programs at a lower price point, right? So it would absolutely be the case, and is expected to be the case, that at public institutions your tuition is going to be a lot lower because they are being directly subsidized by the taxpayer. right? I mean, some community colleges in the U.S. have budgets that are 50, 60, 70, 80% from government subsidies. So, and again, I'm not saying that's good or bad, but my point is you would absolutely expect public institutions to have much lower tuition rates because of that, and as a consequence, you see people borrowing less because the lower tuition rates, they can often cover tuition with, say, just a Pell Grant. And remember, those statistics were strictly for folks taking out Stafford loans and borrowing. They didn't include federal grant information. It's a good question. All right, so that's our last question. Boy, for those of you who stuck through all 4 of the webinars in this series, thank you so much. We really appreciate having you. We hope we were helpful and that you learned something. Happy holidays to everyone. Drive safe, be safe, and we will talk to you soon.